Real estate is commonly the largest valued asset that a farm family owns. Accordingly, it's important to properly title the land so estate planning goals and objectives can be ultimately satisfied. Roger McEowen with the Washburn University School of Law joins us now for today's Rural Money segment. We appreciate you being with us once again. Let's start with some background on the tenancy in common and how it differs from joint tenancy in regards to property titling.
Well, that's a good question, Tammy. The distinguishing characteristic of joint tenancy is the right of survivorship, with the surviving joint tenant or tenants taking all upon the death of the fellow joint tenant, regardless of the terms of the deceased joint tenant's will or trust or whatever dispositive instrument they might have. So in other words, when a joint tenant dies, unlike a tenant in common, the deceased joint tenant's share in the property passes automatically to the surviving joint tenant. It does not pass to the heir of the deceased joint tenant or tenants. Upon the last of the death of the joint tenants, then the joint tenancy is extinguished.
So tell us why knowing this difference matters.
Oh, it matters for big reasons, not the least of which is estate planning and business planning succession reasons. If we have the land titled appropriately, then into the next generation as to who is going to actually own the property. Plus, it can matter from a tax standpoint, too, depending on how that property is titled. So it really matters, and the key distinguishing feature is that language in the deed, whether it says with rights of survivorship or not. If it does say that, then you got a joint tenancy. If not, it's a tenancy in common that the deceased tenant's interest is going to pass then in accordance with their will or their trust or state law.
Can you give us a quick example of that?
Yeah, there was an example coming from a recent case out of Texas, and this was a couple that had 7 kids, and they also owned a tract of land. And on the last of the parents to die, each child held an undivided 1/7 interest as tenants in common in the tract. They just sold the kids. They sold the serving a royalty interest of oil and gas company. And so the oil and gas company started extracting the oil and gas and paying the royalty. And as the kids continued to die, the oil and gas company would pay to the surviving kids, not to the children of the kids, in accordance with the language in the deed. And one grandchild student said, no, we're entitled to royalty. And the court said, no, you're not, because this was a joint tenancy. It was not a tenancy in common, so it passed to the surviving children of mom and dad. It didn't go down the line of each particular child as they died, and that didn't meet the expectations of the grandchildren. But the point is the language in the deed controls. You got to watch that language very carefully.
Those details matter. Thank you so much. That's Roger McEowen with Washburn University School of Law. Appreciate that information today.